With a key court hearing scheduled for July 29th, attention has shifted to what could become the next major chapter in Prince Harry's legal battle with associated newspapers. Unlike the trial itself, this hearing is expected to focus on the financial consequences of the case, including how legal costs may ultimately be allocated. After months of courtroom proceedings, the discussion is now moving from legal arguments to financial accountability. The renewed interest has also brought attention back to an interview published by People magazine in August 2024. In that report, a former Archewell employee claimed that Meghan Markle fully supported Harry but wished he could move beyond the ongoing lawsuits and focus on family life. At the time, those comments attracted relatively little attention. However, following the court's ruling, some commentators have revisited the interview, arguing that it now carries a different context than it did when it was first published. Since then, circumstances have changed considerably. The High Court dismissed the claims after a lengthy trial, and the case has entered the stage where legal costs are expected to be determined. Reports have estimated substantial combined legal expenses, with insurance expected to cover only part of the total. The remaining amount, if confirmed by the court, is expected to be addressed during the July 29 hearing. Media outlets including Newsweek, Yahoo Entertainment, and other royal correspondents have reported the scheduled hearing date, noting that it represents an important procedural step rather than a continuation of the trial itself. The court is expected to consider questions surrounding costs, potential recovery mechanisms, and any additional financial rulings that may arise from the judgment. Commentators have also revisited the contrast between the Sussex's position in 2024 and their current circumstances. At that earlier stage, several commercial projects were still active, and the legal proceedings had not yet reached trial. Today, however, analysts point to a different financial landscape, with ongoing discussions surrounding business partnerships, security expenses, and future commercial opportunities. The August 2024 comments published by People magazine have therefore become part of the broader public conversation. Some observers interpret them as reflecting concerns about the personal and financial impact of prolonged litigation, while others caution that they represent the perspective of a single unnamed former employee rather than an official statement from the Duke and Duchess of Sussex. Another point discussed in media coverage involves reports published by The Times, which stated that settlement discussions were explored before the trial formally began. According to those reports, informal approaches were considered, but ultimately did not lead to an agreement, and the case proceeded through a full trial before the High Court. Those reports have prompted further debate over the legal strategy pursued by both sides. Following the judgment, Harry publicly criticized the outcome, while the court concluded that the claims had not been proven based on the evidence presented. Legal experts have since noted that the upcoming costs hearing is a separate legal process, and that its outcome will depend on established court procedures rather than public commentary. As the hearing approaches, attention remains focused on official court records, publicly available documents, and reporting from established news organizations. Whatever the final outcome, the July 29 proceedings are expected to provide greater clarity regarding the financial consequences of one of Prince Harry's most closely watched legal battles. The case has generated intense debate, with commentators questioning both the legal strategy and the public messaging surrounding the proceedings. Some royal correspondents argued that communication from the Sussex team appeared inconsistent, pointing to reports that details of Harry's travel plans were circulated and later revised within a short period. Critics viewed those changes as adding to the confusion surrounding an already high-profile case. Another topic that attracted attention was a report published by The Times on July 8, 2026, stating that Prince Harry and several co-claimants had explored the possibility of resolving the dispute before the High Court trial began. According to the newspaper, informal settlement discussions were attempted through an intermediary in late 2025. The report said those efforts did not result in an agreement, and the case proceeded to a full trial, Legal observers note that pretrial settlement discussions are not unusual in complex civil litigation. Parties often examine whether an agreement can be reached before committing to lengthy and expensive court proceedings. In this instance, however, the reported negotiations were unsuccessful, leading both sides to continue through the judicial process until judgment was delivered. Following the court's decision, Prince Harry released a statement criticizing the outcome, describing it as a whitewash. The judge, meanwhile, concluded that, although suspicions had been raised, the allegations had not been proven on the evidence presented during the trial. Those two positions have since become central to public discussion of the case. Legal experts have also commented on the upcoming costs hearing, explaining that courts may consider a range of factors when deciding how legal expenses should be allocated. Former cost judge Colin Campbell told Business Matters that, in certain circumstances, courts can consider enhanced costs orders where a party's conduct is found to fall outside the normal standard. Whether that threshold is met depends entirely on the court's assessment of the case and should not be assumed in advance. Attention has therefore shifted from the trial itself to the financial issues that remain unresolved. Media reports have discussed insurance arrangements, potential liability for legal costs, and the mechanisms available under civil procedure rules. However, the final outcome will be determined only after the scheduled hearing, when the court considers the evidence and submissions from both sides. For now, the July 29 proceedings represent the next significant stage in a closely watched legal dispute. Rather than revisiting the trial's factual findings, the hearing is expected to focus on costs and the financial consequences of the litigation, with any decisions resting solely on the court's judgment and the applicable legal framework. Legal analysts following the case have focused on the financial implications of the upcoming costs hearing. According to media reports discussing the proceedings, the combined legal expenses have been estimated at roughly £50 million, while insurance is expected to cover only part of those costs. If those figures are confirmed, the remaining balance will become one of the key issues before the court. Commentators have also compared those potential costs with Prince Harry's ongoing private security expenses, noting that both involve substantial financial commitments. While the comparison has attracted attention, the court will ultimately determine any legal liability rather than commentators or media outlets. Another issue discussed by legal observers is the principle of joint and several liability, which can apply in some civil cases. Under that principle, responsibility for recoverable costs is not necessarily divided equally among claimants. Instead, the successful party may seek recovery in accordance with the court's rules, after which any allocation between claimants may become a separate matter. Whether that principle applies in this case depends entirely on the court's ruling. Beyond the courtroom, commentators have connected the litigation to the Sussex's wider commercial position. They note that the legal proceedings have unfolded alongside changes to business partnerships and other commercial ventures, prompting discussion about the financial impact of prolonged litigation. Others argue that legal decisions should be evaluated independently of commercial activities and public perception. Media reports have also revisited comments published in People magazine during 2024, alongside subsequent developments reported by several news organizations. Supporters of Prince Harry maintain that the legal action reflected his long-standing concerns about media practices, while critics question whether continuing the litigation remained the best course once settlement discussions reportedly failed. A timeline assembled from publicly reported events shows how the case progressed, from early settlement discussions through the High Court trial to the judgment and the forthcoming hearing on legal costs. Those events have become the focus of renewed public interest as observers await the court's next decision. For now, the central question is no longer whether the trial will continue, it has concluded, but how the financial consequences will be resolved. The July 29 hearing is expected to address those remaining issues, with the final outcome determined by the court based on the evidence, legal submissions, and applicable procedures rather than public commentary. Multiple outlets run it. July 6, 2026. 3 hours later, Palace denies. Outlet retracts exclusive on air. Harry's spokesman issues statement over the weekend, places acceptance after the stated Friday deadline. July 7, 2026. All 97 allegations dismissed. Harry calls it a whitewash. Annal announces $50 million in costs. Signals recovery pursuit. Meghan, California. Harry clearly broken and all alone per Charlotte Griffiths. July 8, 2026. The Times publishes the December 2025 settlement attempt. Former costs, Judge Campbell warns of indemnity costs exposure. July 29-30th. 2026 costs hearing, $22.6 million gap. Indemnity mechanism available. Damages to be assessed. 4 categories. No speculation. Category 1. The $40 million precedent. The number first. Then the mechanism $40 million. That's what Richard Desmond's Northern and Shell paid in costs on the indemnity basis following a failed claim. That precedent is named documented directly applicable. Former cost judge Colin Campbell identified the gateway conduct outside the norm. His July 8 assessment. Indemnity cost recovery is available, and the difference from standard recovery could amount to a significant amount of money on a $50 million case, where one party publicly called the judge corrupt, 3 weeks before the costs hearing. That threshold is worth watching on July 29th. Category 2 joint and several anal doesn't have to divide the recovery into 7 equal shares. They pursue the deepest pockets first. The $3.23 million individual average is not Harry's maximum exposure, it's his proportional share. If anal chooses equal division, they don't have to. Category 3. The whitewash statement making a public accusation of judicial impropriety in an official statement, while the same court system determines your costs in 3 weeks, is the specific conduct the indemnity threshold addresses. This is documented, named, and sitting on the calendar. Category 4. The commercial consequence as Evers' commercial premise is royal association. This week produced documented evidence of the opposite. A palace dispute, a lost court case, a family that couldn't travel under the security arrangement they demanded, a spokesman's statement that contradicted itself. I think Harry knew he was going to lose. This is a last-ditch effort. So, back in December 2025, there's a very interesting article on the Upsetter Substack right now, and it has an interview of a man who actually tried to intervene and get the Daily Mail to settle after all of the evidence was made public. It was around Christmas time, and Harry and team knew they were up a creek without a paddle. They saw all the notebooks. They saw everything that the Daily Mail had. They tried to settle. The Daily Mail pretty much went, "No, we shall not. Let's go to court." They wanted to put the nail in that coffin, and right now he's financially up a creek, reputationally up a creek. Every commercial partner has or seeks is built on the premise that Meghan Markle is a former working royal with active institutional connections. That premise just had its worst documented week on the public record, and July 29th arrives 22 days later. Here's the calculation. Once plainly, a former Arwell Foundation employee told People magazine in August 2024 that Meghan wished Harry would let go of the lawsuits, identifying herself as the reason he couldn't. And on July 29th and 30th, 2026, a costs hearing will legally determine his individual liability on a case he tried to secretly exit in December 2025 through a retired police detective go-between that he publicly called a whitewash after losing, and that generated $50 million in combined costs, with $22.6 million currently uncovered by insurance. While the Netflix equity that existed when the warning was issued is gone, the UK Visit commercial strategy produced zero Royal Association content, and the lifestyle costs run at $45 million per year. The warning was issued when there was still money to absorb the loss. The hearing arrives when there isn't. So here's my question. Specific answer, not a theory. The People magazine source said Meghan wants Harry to live in a world where he's not burdened by this. That was August 2024. The December 2025 settlement attempt shows Harry's own team was trying to exit before he testified. And Nell refused. The trial ran. Every allegation was dismissed. Between August 2024 and January 2026, at what point did Harry's legal team tell him the evidence wasn't strong enough to win? And why did they proceed past December? Tell me what you found, not what you believe, what you found.